one kick also started.
शुरू कर रहे हैं स्टार्ट हो गया हम just changing फाइनल्स एंड वैलिडिटी चाहिए refresh command है शिफ्ट दबाना ट्राई कर रहा है दिमाग में चल रहा है Is it live?
Check on the app.
May I request the audience to please settle down so we can begin with the rounds? Good evening, ladies and gentlemen. It gives us immense pleasure to welcome everyone present here to the final round of arguments for the 25th DM Harish Memorial Government Law College Moot Court Competition 2024. I am honoured to welcome Honourable Judges of the Bombay High Court, Honourable Chief Justice Riaz Chawla and Honourable Chief Justice Milind Jadhav, who will be presiding over the final round of arguments for this evening. I would like to request the Honourable Judges and the finalists to commence with the final round of arguments. We look forward to a competitive and enthralling round.
A very good afternoon, Your Excellencies. In the matter of the Republic of Zimbabwe versus the Republic of Avantara, which is before this court today, we seek to represent the applicant, the state of Zimbabwe. Zimbabwe is a developing country that has been through the throes of financial distress. The actions of Avantara, which bring us before this court today, have decimated our federal reserves and legal tender, impaired our ability to maintain financial stability, and substantially increased the risk of reducing our population to penury. We request this court to not allow such a gross violation of the principles of international law to go unpunished. There are 4 key issues before this court. My co-agent will take 14 minutes to deal with issue 2 pertaining to attributability and defenses, as well as issue 4 pertaining to economic impact and reimbursement. I will take a total of 14 minutes to deal with issue 1 pertaining to state responsibility and issue 3 pertaining to ex-DAO statehood. We will be speaking in the order of issue 3 followed by 1, 2 and 4. With this, I now proceed to my arguments on issue 3 pertaining to the question of ex-DAO statehood. Here we seek to demonstrate that ex-DAO fulfills the criteria for statehood as provided by the customary Montevideo Convention. This court must note that the Montevideo Convention is a treaty that came into force in the 1930s, a time when elements like the internet and blockchain were barely at the forefront of discussion in the international realm. Relying on the interpretive tools provided by the Vienna Convention on Law and Treaties, particularly Article 31, Clause 1, we argue for an expansive interpretation of the terms provided in the Montevideo Convention, insofar as we are applying it in a radically altered context. The Montevideo Convention provides a conjunctive test consisting of 4 prongs that an entity claiming statehood must fulfill. The first prong deals with the requirement for a permanent population. We submit that the members of ex-DAO fulfill the permanent population requirement. The permanent population requirement has been interpreted as referring to a distinguishable section of people who consistently remain part of the entity claiming statehood. In this case, the members of ex-DAO, insofar as they can be distinguished from non-members and consistently remain part of the NGO's efforts, can be classified as permanent population for the purposes of this prong. The second prong deals with the requirement for a defined territory. Your Excellencies, the need for a defined territory arises because it is over this realm that a state exercises its exclusive authority. Without this realm, it cannot exercise its state functions. In this case, we submit that the smart contract, which governs the creation and everyday functions of ex-DAO, fulfills this prong of defined territory. In this case, the part of the blockchain network over which ex-DAO's smart contract is executed represents the realm over which it exercises complete authority. In this realm, ex-DAO and its members exercise cumulative control over the part of the blockchain network. Insofar as they have a territory over which they exercise exclusive control and can perform their functions, this fulfills the requirement of defined territory under the Montevideo Convention. Yes, Your Excellency.
Don't you have to have a border defining territory? Because usually that is also one of the requirements because of border security, which is a requirement in defining whether it is a state.
Yes, Your Excellency. The requirement for borders is that you must have a defined boundary, even though the exact contours of the same may not have been determined. So there may often be a case where a state knows that it has a boundary, but those boundaries may be under contestation because of some international conflicts. In this case, the smart contract is executed over a part of the blockchain network. Over that part of the blockchain network, we know that ex-DAO exercises complete control. And that part constitutes the defined territory for the purposes of the Montevideo Convention. The third prong deals with the requirement for a government. We submit that the terms of the smart contract constitute government for the purposes of this prong. A government is an institution or organ that is sovereign and habitually obeyed. This indicates 2 elements. First, an element of external sovereignty, which means that the government cannot be unreasonably influenced by external forces. And second, an element of internal sovereignty, which means that its policies, directives, and orders are habitually respected and obeyed by its population. In this case, this function is discharged by the terms of the smart contract. This smart contract cannot be altered by external forces. The only alteration is possible when there is compliance with the very provisions that are provided in this contract. This establishes an element of external sovereignty. Once again, the terms of this contract govern the scope and conduct of the members. There can once again be no deviation from the standards given by this contract. This represents an element of internal sovereignty. Insofar as the terms of this smart contract have both elements of external and internal sovereignty, we submit that it fulfills the prong of government under the Montevideo Convention. The fourth and final prong of the Montevideo Convention requires a capacity to enter into relations. If your excellencies may have para 2 of the compromise, you will find this on page 5, your excellencies. Page 5, para 2. Are your excellencies with me?
Page 5, para 2.
Of the compromise, your excellencies. Of the compromise, the problem before this one.
Page 5, you said?
Yes, your excellency.
Is it titled resolution adopted by Congress?
No, your excellency, the compromise. Yes.
Yes.
If I may just read the second last line to your excellencies. Owing to its regular mentions in the media and references made by global leaders, this organization, which refers to XDAO, has gained significant prominence in human rights discussions. Your excellencies, this indicates that XDAO has emerged as an acknowledged participant in the realm of human rights discussions in the international realm. This signifies its ability to enter into relations with other states in any point in the future with regard to its work. This signifies its capacity to enter into relations. Insofar as we have established that XDAO fulfills the 4 prongs of the Montevideo Convention, we plead that its claim for statehood be recognized by this court. I will now move to my arguments on issue 1 pertaining to the question of state responsibility. Here we seek to demonstrate that Avantara's actions indeed constitute a violation of the principles of state responsibility on the basis of 3 prongs. First, the violation of sovereignty. Second, the violation of non-intervention. And third, the use of force standard. Before that, let me give your excellencies an analogy. Let us say country A transports its entire legal tender in a truck. Now country B attacks this truck with a missile, completely obliterating the legal tender held within. Now country B, which has caused the attack, seeks to evade liability by stating 2 things. First, that the attack was caused not by the country itself but by the missile it employed. And second, that the target of the attack was not the currency but the truck itself. This is precisely the situation we find ourselves in. In this case, the attacking country is Avantara, the missile it has employed is Eagle Eye, the truck is the EtherX blockchain network, and the currency held within is Bitnev. It is on that basis that we will proceed with our prong on sovereignty. Sovereignty refers to an ability to perform certain inherently governmental functions that are characteristic of and crucial to the state. A violation of this principle will occur whenever a state is prevented from exercising these inherently governmental functions. This violation of inherently governmental functions may occur through a range of means, and cyber intrusions have been recognized as one such mode. For the purposes of clarity, a violation of sovereignty occurs when inherently governmental functions are prevented from being performed, and this violation can occur through cyber means. There can be no doubt, Your Excellencies, that maintaining your financial system and financial stability constitute inherently governmental functions and are a part of your sovereignty. In this case, the financial system of Zimbabwe, comprising its legal tender and federal reserves, have been absolutely decimated. If your excellencies may have para 24 of the compromise, you will find this on page 9. And once again, if I may read out the second last line. As news of the attack spread, the market price of Bitnero plummeted from 30,000 US dollars to zero. Your excellencies must note that Bitnero is my legal tender as well as a part of my federal reserves.
No, but isn't that, so far as your currency is concerned, it might have plummeted, but isn't that capable of reviving? What the worry is that it may be a temporary setback, but so far as the Bitnero is concerned, it may always come up again.
Your excellency, that is the problem we encounter here. If I may take you to just one line above, and I will read the same. Eagle Eye launched a series of sophisticated cyber attacks and brought down the EtherX network and permanently corrupted all Bitnero data. The action which has been taken here is an irreversible action that has prevented me from utilizing a particular currency as my legal tender and entirely devalue a crucial part of my federal reserves.
But as the compromise shows, 13% was utilizing the Bitnero. So does it have that much of an impact over the entire population, or is it just a
Your Excellency, in the question of sovereignty, the focus is not on the impact, but on the fact that the applicant has been prevented from exercising its function in a domain which is so crucial to its very existence. We're talking about a financial system where I control my legal tender and my federal reserves. Insofar as I've been prevented from exercising authority in that realm, there has been a complete violation of my principle of sovereignty.
That's because it was declared as a state currency. That is the reason why you are arguing this point.
Yes, Your Excellency. Now I move to my argument on the second prong of the violation of non-intervention. We submit that there has been a violation of this principle under the UN Friendly Relations Declaration insofar as there has been interference in the economic elements of state function. Your Excellencies, the UN Friendly Relations Declaration is a UNGA resolution that was adopted in 1970 without a vote, signaling the consensus of all member states to uphold its principles and respect its principles. It has also been recognized as customary law by this very court. This Friendly Relations Declaration explicitly prohibits both direct and indirect intervention in realms of political, economic and cultural elements of state function. Once again, in this case, the actions of Avantara through Eagle Eye have decimated our Federal Reserve and prevented us from utilizing Bitnero as a legal tender. This is undoubtedly a question of an economic element of state function. Insofar as we've been prevented from exercising control over this realm, there has been a violation of the principle of non-intervention. The third and final prong deals with the requirement and the principle of use of force. Your Excellencies, Article 2, Clause 4 of the UN Charter prohibits the use of force in a manner that challenges the territorial integrity and political independence of states. If I may seek a 30-second extension. However, with the emergence of new threats in the international realm, there has been an expansion of what constitutes a threat to the elements that Article 2, Clause 4 seeks to guard against. One such expansion is seen in the realm of critical infrastructures. Your Excellencies may have the UNGA resolution from 2004. You will find this on page 5 of the compendium. This UNGA resolution indicates the importance of certain critical infrastructures to a state's function. The importance seems to indicate that an attack on these critical infrastructures would be akin to challenging the territorial integrity and political independence of states. Once again, there is ample state practice to indicate that financial services have been included within the ambit of critical infrastructure. And not to reiterate my point, there has again been a damage to Federal Reserves and my legal tender. Insofar as my financial services, which constitute critical infrastructure, have been affected, and damage to critical infrastructure violates use of force, we submit that there has been a violation of the use of force prong. To conclude, I will say that in addition to the damage and violation of the principles of sovereignty, non-intervention and use of force, the impunity with which Avantara has acted symbolizes a threat to the very idea of a rules-based international order. We only pray that such a violation should not be allowed to go unpunished. That would be my submissions on this case. My co-agent will deal with issue 2 and 4.
Good afternoon, Your Excellency. I am the co-agent representing the state of Zambia in this case. As argued by my co-agent, what has been committed here is a grave breach of international law that has affected the African state deeply. Zambia, already suffering from economic turmoil, has been struck badly by the actions of the respondent, which attacked its legal tender. This attack was carried out by Eagle Eye, an AI built, deployed, programmed and designed by the respondent state for its own security. And now, to escape liability, respondents are trying to deny the connection they have to an AI they themselves created. I will be arguing on issues 2 and 4, which deal with the aspects of attributability and defenses and reimbursement respectively. Under issue 2, I have two broad submissions. Firstly, that the actions of Eagle Eye are attributable to Avantara, and secondly, that none of the defenses claimed by the respondent are applicable in this case. Under my first submission, we submit that the attack is attributable under Article 4 and 8 of RCEBA. Article 4 of RCEBA was considered as customary international law in the Genocide Convention judgment of the ICJ. It makes state liable for actions of an entity which can be considered as an organ of the state. The standard of organ as defined in the case and also in the commentary to RCEBA is that of an entity acting on behalf of the state, appearing as its agent and working in apparent official authority. I would like to draw your attention to para 17 on page 7 of the complaint. Is Your Excellency with me?
Yes.
The first line reads, "And the Republic of Avantara has built and deployed Eagle Eye, a cutting-edge artificial intelligence system designed to detect, investigate, and neutralize threats to national security." Also, on para 21 of the compromise, which mentions the functions of Eagle Eye, it states that it protects border security of the national borders of Avantara and the critical infrastructure, which is the national infrastructure of Avantara itself. So in this case, Eagle Eye is functioning like an organ of the defense sector of the state, which is considered a part of the executive organ of a state. It is functioning as an organ because it is protecting the national security of Avantara from threats that show up against the state. In this context, its acts become attributable to the state of Avantara.
Just one thing. There's no human intervention, right, insofar as AI is concerned, which technology we're using. So how is that attributable to the state, in a sense, controlled by the state?
Yes, Your Excellency. The standard under Article 4 states that it should be an organ of the state within the organizational structure of the state. This entity has been created by Avantara. It has been programmed by Avantara. So maybe the state is not informed of a specific attack it does, but overall its working mechanism has been designed by Avantara. It is like a military unit which maybe a country would create, and then it would say we are not liable for its actions because we are not directing who it is attacking. But it is programmed, it is told its functions by the state itself. So it functions as an organ of the state. Yes, Your Excellency. With this, I move to my submissions under Article 8. Article 8 of RCEBA makes state liable for actions of an entity which works on its instruction, direction or control. Two tests exist in the international sphere for it. The effective control test created in the Nicaragua versus US judgment and the overall control test created in the prosecutor versus static judgment. The static judgment differentiated between these two. It said effective control is to be used in the case of individuals and unorganized groups, and overall control is to be used in the case of organized military units. In this case, I would draw your attention to para 19 on page 8 of the compromise. Is Your Excellency with me? The second line reads that the system can automatically deploy countermeasures in cyber scenarios. The next line states, in physical threat scenarios, it can provide real-time intelligence to ground forces. So it is not like an individual performing a single attack. It is an entity performing attacks at different points of time based on the threat that shows up against the state. This is equivalent to an organized military unit of the state. Based on this, the overall control test applies in this case. The standard of overall control is that the entity should be equipped, financed, and generally programmed and coordinated by the state. In this case, Eagle Eye has been built and deployed by Avantara. Also, its overall working mechanism, like it is attacking cyber threats but informing of physical threats. This programming has been done by the state. So the overall working mechanism is of the state. So the standard of overall control is met in this case, and Article 8 attributability applies to the state. As the actions are attributable, I move to my second prong under issue based on the defenses which do not apply in this case. In this case, Eagle Eye's algorithm predicted that Bitnero has a high probability of being used for terrorist financing activities. It is based on this probability, using it as a shield, that the respondent is arguing defenses of self-defense, necessity, and countermeasure. We submit that none of these defenses are applicable in this case. Firstly, because the standard of only way required for necessity is not met. And secondly, the defense of self-defense and countermeasure cannot apply in case of non-state actors. Moving to my first submission under necessity, Article 25 of RCEPA, considered as customary international law in the CMS Gas Transmission Company case, states that for necessity, it should be the only way to protect an essential interest from a grave and imminent peril. In this case, as I will draw your attention to para 24 on page 9 of the complaint. Is Your Excellency with me? Para 24 reads that Eagle Eye launched a series of sophisticated cyber attacks and brought down the EtherX network. So in this case, the respondents brought down the entire network of the currency. This was not the only way available to them. In case of cryptocurrency, different forms of attack are available, like systemic attack, theft, and spending denial. The other two forms of attack only target the specific entity and prevent its transactions. So if the respondent had deployed these forms, they would have targeted Crimson Road directly and prevented the terrorist financing that was occurring on Bitnero network.
But how does one specifically deal with the terrorism, terrorism which is being funded? How would one concentrate on that particular without being taken?
Yes, Your Excellency. This is connected to the forms of attack one can conduct. In case of cryptocurrency, you can trace which particular entity is performing the transactions, and then you can attack that entity by preventing it, like placing a block so that it cannot conduct any future transactions. This is the way these different forms of attack work. What the respondent did in this case is, because some illegal activity was happening on a forum, they destroyed the entire forum. And this did not even prevent the illegal activity, because here Crimson Road can now move to some other cryptocurrency and conduct the same illegal activities. So they
Was that illegal activity identified,
the illegal activity was,
or was it just in that general sense of the algorithm that it just visualized something and it just attacked it? Was it identified?
Your Excellency, Eagle Eye, the AI here, identified that the illegal activities like terrorist financing and money laundering were happening. But the compromise itself states that it detected there was a high probability that this was happening. And based on this probability, it attacked the entire currency network, which was the legal tender of our country. Since it was not the only way available, the defense of necessity does not apply to this case. This will take me to my second prong under defenses. That is, the defense of self-defense and countermeasure do not apply in case of non-state act. Self-defense under Article 51 of UN Charter is against an armed attack. The ICJ, in the legality of construction of wall case, said that Article 51 is against attack by a state. In this case, the attack is by Crimson Road, which is conducting the terrorist financing. Crimson Road is a non-state actor, rather a dark web market, whose self-defense cannot be claimed against the threat posed by a non-state actor under international law. And so, the defense of self-defense should not apply to this case. Even in the case of countermeasures, they are used in international law to prevent states which are already conducting internationally wrongful acts from continuing to commit those. So countermeasure is like an interstate obligation. So because they are conducting an international wrongful act, the other state decides not to fulfill its obligations towards that state. Now in this case, no state is conducting any internationally wrongful act. The entity conducting internationally wrongful act is Crimson Road, a non-state actor. So the question of interstate obligation does not arise. And so the defense of countermeasure cannot be applicable to this case, as it is attributable to Avantara and none of the defenses apply. The respondent is liable for the internationally wrongful acts conducted. If Your Excellency have no further questions, I would move to my next issue. Issue 4 deals with the aspect of economic reimbursement. Bitnero was not only the legal tender of Zimbabwe, it was also used to hold large amounts of reserves and was also used for foreign investment to gain permanent residence. This attack reduced value of Bitnero from $30,000 to zero, causing huge economic loss to Zimbabwe. The standard of reimbursement, as laid down in the Genocide Convention judgment, is that if the injury would not have been caused but for the wrongful acts or the lack of preventive measures of the respondent, then it is liable to pay complete reparation. In this case, clarification 15 of the compromise states that no safeguards or limits were placed on the working of Eagle Eye by Avantara. Since no safeguards were placed, the lack of preventive measures by Avantara led to the programming of Eagle Eye in such a way that it attacked the entire currency network, causing this loss, making it liable to pay complete reparation in this case. The applicant claims compensation, which under Article 36 of RCEBA can be claimed for all financially accessible damages. In this case, there are three forms of financially accessible damages. Firstly, loss of value of currency as reserves, those in transactions, and those held in foreign investments. The applicant claims compensation for all these losses. With this, we humbly request the court to declare that the respondent has committed an internationally wrongful act, making it liable to pay reparations, and also recognize ex-DAO as a state. Let this case set a precedent so that no other technologically powerful country can ever conduct such an attack, destroying the basic working structure of an economically distressed nation like Zimbabwe. Thank you, Your Excellency. If you have no further questions, I rest my submission. Thank you, Your Excellency.
Greetings to the bench. May it please the court, the agent seeks permission to address the bench individually and collectively as Your Excellencies. Your Excellencies, the agent stands before this honorable court on behalf of the respondents, Republic of Avantara. The agent shall be taking 16 minutes of the court's time to argue on issue 1 and 2, which deal with the contention on state responsibility and the defenses applicable in this particular case. My co-agent will then make submissions for a period of 14 minutes on issues 3 and 4. If Your Excellencies are acquainted with the facts of the case, the agent seeks permission to make submissions on issue 1. Much obliged, Your Excellencies. Your Excellencies, issue 1 is whether the Republic of Avantara has violated the principle of state responsibility. The submission of the agent before this honorable court is that for the application of principle of state responsibility under Article 1 of RCEBA, there should be an internationally wrongful act. However, in this particular case, there is no internationally wrongful act as there is no legal obligation which has been breached by the cyber attack. The same shall be proved using two limbs of the argument. Firstly, that there is no violation of principle of sovereignty as the actions do not amount to use of force or intervention. Furthermore, the second submission is that there is no violation of obligation of due diligence as well in this case. Proceeding with the first limb of the argument, Your Excellencies, a state can exercise sovereignty over those entities on which it can exercise its control. For example, a state exercises its control over its territory, over its people through the laws it makes, and therefore it has sovereignty over these entities. However, if you may refer to paragraph 10 of the Moot compromise, it suggests that, if Your Excellencies are with me, much obliged. Your Excellencies, Bitnero functioning on EtherX platform, which is a permissionless blockchain, the state of Zimbabwe does not have any control over EtherX or Bitnero. And when the state does not exercise any control over an entity, the state does not have sovereignty over the same. Therefore, the contention here is that there exists no sovereignty over EtherX and Bitnero in the first place for there to be any subsequent breach of the sovereignty. Having established the same, the agent submits before this court that Article 2 Clause 4 of the UN Charter, which prohibits use of force, is also not fulfilled in this particular case. If we interpret this Article 2 Clause 4 using the rule laid down in the Vienna Convention of Law on Treaties, which states that it shall be interpreted using the Tavox preparatory, which means that the intention of the charter maker should be considered to understand the term. If the Excellencies may refer to marker number 6, which is page 35 of the compendium. Indeed, Your Excellencies. Your Excellencies, it is stated that the makers of the UN Charter construed the term use of force to only mean military use of force. All the other proposals to include political and economic forces were rejected by the committee. This shows that the term use of force only means military attacks and nothing beyond the same.
That was in 1945. Now we have advanced.
Indeed, Your
And when a
Excellencies.
sovereign nation recognizes Bitnero as its legal tender, in that case, what happens?
Thank you for that question, Your Excellency. Your Excellency, as held in the Tallinn manual, which has been done in the recent times where cyberspace activities started to happen, it is held under Rule 69 that a cyber attack can be construed as use of force only when it can be equated with a military attack. So even if a cyber attack is launched against a state, as long as it does not damage the physical property of a nation or lead to loss of lives, then such a cyber attack cannot be construed as use of force. The same is held in marker number 8, which is page 62 of compendium, Your Excellency, where it is suggested that unless there is physical damage to any property or loss of life, the cyber attack cannot be construed as use of force.
Here there has been a physical damage in one sense to the entire nation.
Indeed not, Your Excellencies. Bitnero functioning on a permissionless blockchain of EtherX, held by only 15% of the nation, cannot be considered as its physical territory, nor can it be considered as a nation's critical infrastructure as argued by the applicants, because the state does not have its sovereignty over EtherX in the first place. Therefore, it cannot be considered as a national's critical infrastructure for there to be any subsequent breach. The agent further establishes that since there exists no sovereignty, there can be no intervention, as held in the case of Nicaragua versus USA. The court said that only when the sovereignty is threatened is the principle of intervention in picture. And for this to be present, the state should have rights to control the entity in question. However, in this particular case, the state of Zimbabwe does not have any control over Bitnero data because it is decentralized. Therefore, the agent humbly submits before this court that the actions do not violate the sovereignty of Zimbabwe, as it does not amount to use of force or intervention under international law. Furthermore, the agent humbly submits before this court that as provided in the Tallinn manual, the states are not expected to carefully monitor their cyberspace just like how they monitor their military infrastructure, because it is unreasonable to exercise the same level of control in their cyberspace, because the architecture of cyberspace is so autonomous that the states, even if they take actions, certain activities cannot be controlled. Therefore, it is humbly submitted before the court that the state of Aventara, by deploying Eagle Eye, has not violated its principle of due diligence as well. Having established that there is no legal obligation which has been breached in this present case, the agent humbly submits before the court that there is no internationally wrongful act in this case for there to be application of principle of state responsibility.
This problem very was there a deliberate attack on this Methodex network, and because of that, it has brought down the entire network which India was using. What do you have to say about that?
Your Excellencies, the answer to this question is in two limbs. Firstly, that this attack, since it has not threatened the sovereignty, is not an internationally wrongful act. Furthermore, this attack on EtherX network was taken as a measure of necessity, self-defense and countermeasure, therefore is protected in the international law, which will be elaborated in issue number 2 of the agent. If your Excellencies have any further questions regarding issue 1, the agent shall be pleased to answer this. Much obliged, Your Excellencies. Your Excellencies, issue 2 is whether the state of Aventara can evade its liability by claiming certain defenses available in international law. The first submission of the agent regarding this issue is that Eagle Eye acted autonomously and its actions were unforeseen and not directly commanded. Your Excellencies, clarification number 10 of the Moot compromise suggests that Eagle Eye was an out-of-the-loop artificial intelligence functioning without any human intervention. It's functioning in such a way that even though it was deployed by Aventara, it has its own learning mechanisms and deploys actions without any form of human intervention or state control for its actions. Out-of-the-loop AI is when there need not be any input to the AI for the AI to function in a certain manner, which is to say that the cyber attack conducted by Eagle Eye was not effectively controlled by the state of Aventara. Furthermore, Your Excellencies, as established by this very court in the Bosnia genocide case and the Nicaragua versus USA case, the court said that for attributability under Article 8 of RCWA, there has to be effective control over that particular mechanism. In the case of Nicaragua, the court said that even though USA had deployed certain contras in the case, USA was not directly involved in every attack of the band, which is to say that for the attacks USA directly involved, it would be held responsible. For attacks it was not effectively controlling, the state would not. And therefore it is established that if the state was not actively involved in that particular attack, mere deployment is not enough for the state to be held responsible. If Your Excellencies may refer to marker number 1, which is page 3 of the compendium. Your Excellencies, this very court has established that effective control test should be applicable in cases of attributability to actions of autonomous or private entities. However, the applicants have further claimed that Article 4 should be applied, which is applicable only to organs of the state. Even though the state of Aventara had deployed Eagle Eye, Eagle Eye cannot be considered as the organ of the state because, as established in RCWA, internal law of the state is very important to consider something as an organ. And there is no internal law in Aventara saying that Eagle Eye is its organ. And organs of the states are usually political organizations such as its legislature, executive and judiciary, also acknowledged in the ILC articles and the commentary attached to the same, which is to say that mere deployment of Eagle Eye by Aventara does not make it an organ of the state.
Are you saying that Eagle Eye was not created by Aventara?
Indeed, Your Excellencies, Eagle Eye is an autonomous entity functioning without any form of intervention by the state of Aventara. Therefore, mere deployment is not adequate under international law for attributability.
So there was no programming of Eagle Eye in any manner. How would Eagle Eye operate without any programming?
Your Excellencies, if you may refer to paragraph number 19 of the Moot compromise, it shows that Eagle Eye was designed in a way that it could automatically deploy countermeasures, which is within the ambit of international law, as international law allows countermeasures to be taken by the entities. And furthermore, as mentioned in clarification number 10 attached with the Moot compromise, it is an out-of-the-loop AI without any human intervention. So even though Avantara programmed Eagle Eye, it was with the right purpose of countermeasures which is allowed in international law. And the mechanism of Eagle Eye is without any human intervention. If I may proceed. Much obliged, Your Excellencies. Your Excellencies, this very court, in the case of Bosnia genocide, has rejected the overall control test. And if you may refer to page number 5 of the compendium,
Effective control test.
overall control test, which the applicants have claimed, Your Excellencies. This very court has held that overall control test is very wide, and if it is applied for attributability, it would destroy the purpose of international law on state responsibility and make every state responsible for whatever actions its entities take. Therefore, it is humbly submitted before this honorable court that the effective control test is applicable in this case, and the state of Avantara is not responsible for the actions of Eagle Eye. If I may proceed with the second submissions. Much obliged, Your Excellencies. Your Excellencies, the agent submits before this court that the actions were taken out of necessity in self-defense and as countermeasures to the imminent threats on this network. If Your Excellencies may refer to paragraph number 23 and 24 of the Moot compromise. If I may proceed. Much obliged. Your Excellencies, there were criminal activities happening in this network, and this included activities such as terrorism, money laundering, drug trafficking, weapon trade, all of which are condemned by the international community as they pose threats to the essential interest of the state and the international community at large. And therefore, this created a situation where the essential interest not only of the state of Avantara, but the international community at large was at threat. This created a situation of necessity under Article 25, where measures can be taken to protect these essential interests. However, this was the only way to protect the interest, as attacking the Crimson Road would have led to them shifting to another Tor network. But the anonymity available using Bitnero would still be present in the case. When this anonymity is present, they cannot be prosecuted for the crimes that they have committed, and therefore, in order to find the culprits and hold them responsible, the only means possible was to bring down the EtherX network. Furthermore, freezing the asset was also not possible, as the cryptocurrency functioned in a certain way that if there is some suspicious activities happening in the transactions in the wallets, it would automatically be removed. However, in this case, since there was anonymity and the transactions continued to happen, it shows that such measures were also not reasonable and was not possible. Therefore, it is humbly submitted that the only measure to be taken to protect the essential interest of the state and the international community at large was to bring down the EtherX network, and therefore is protected under international law.
One query on that. Isn't that a mere presumption that this was going to result in this counter-terrorism, and other illegal activities? That is only a presumption of yours that Eagle Eye, that this was being used. So what do you have to say about that?
Your Excellencies, as held by this very court in the Gapchico Nakimoris project case, it is not essential that the threat is happening at the present scenario. Even if it is a future uncertain event, at that relevant point of time, if there is information that there might be this peril, then that situation is enough for measures to be taken out of necessity. Therefore, the agent humbly submits before the court that the actions are protected under Article 25. Proceeding with the next limb, Your Excellency, which is that under Article 21 of RCWA, if I may get an extension of 2 minutes, much obliged. Your Excellencies, under Article 21 of RCWA and Article 51 of UN Charter, measures can be taken under self-defense if there is an armed attack. However, the prevalent state practice which forms the customary international law is such that even the UN high-level panel on threat challenges and change, and also the national strategy plans of various countries, including USA and China, have adopted the concept of preemptive self-defense for the actions of non-state actors in the light of global terrorism. Therefore, it is humbly submitted that measures of self-defense can be taken against non-state actors if there is traces of terrorism.
The only question which comes to our mind is, what were the reasonable grounds which were taken into account before bringing down Ether-X?
Your Excellencies, if you may refer to paragraph number 23 of the Moot compromise, which suggests that there were criminal activities happening, which shows that this was already happening at present by Crimson Road, and there is enough evidence regarding the same that it included activities of terrorism, counterfeit ID, weapon trade, and even money laundering for terrorism, Your Excellency, showing that there was a situation where terrorist activities were happening. Therefore, the preemptive self-defense principle should be applicable and the measures are within the ambit of international law. Proceeding with the last submission, which is that these criminal activities in themselves are internationally wrongful act as they threaten the sovereignty of the states. And under Article 22 of RCWA and the principle held by this very court in the Gapchivo-Nagi Morris project case, if there is an internationally wrongful act, measures taken against the same are protected under international law as countermeasures. Therefore, it is humbly submitted before this court that the state of Avantara cannot be held liable for the actions of Eagle Eye. If your excellencies are satisfied with issues number 1 and 2, my co-agent will now address issue 3 and 4. It was indeed a pleasure arguing before this court.
Your Excellencies, may it please the court, the agent will be addressing issues number 3 and 4, which relate to contentions on statehood under international law and reparation under international law respectively. Your Excellencies, as far as issue 3 is concerned, regarding the statehood of XDAO under international law, the learned agents for the applicants have established that the customary international law of the Montevideo Convention is applicable in this case, and the respondents do not have any contentions to the same. However, the respondents also bring before this court the essential requirement of independence which is necessary for statehood to be granted. As established by this very court in the case of Island of Palmas, it is true that states are characterized by sovereignty, and today the point of departure for international law is the exercise of such sovereignty or independence, Your Excellencies. Therefore, states being the primary legal personalities under international law, sovereignty is a characteristic of statehood that cannot be overlooked. As far as independence is concerned, Your Excellencies, it becomes important to note as to what is the makeup of cyberspace. Your Excellencies, if you may kindly refer to marker number 16, that is page 198 of the compendium provided, if I may proceed. Yes, Your Excellencies. Your Excellencies, cyberspace is made of 3 layers. First is the physical layer that empowers the cyberspace, that is our servers, laptops, cables, etc. etc. This, Your Excellencies, is not under the control of XDAO because XDAO does not possess any physical nature at all and is only native to cyberspace. Further, Your Excellencies, the other 2 stratums are one, the informational stratum, and the second, the societal stratum within the cyberspace, Your Excellencies. As far as information is concerned, information is within the prerogative of the domestic legislation, Your Excellencies. Various countries as state practice have already decided to regulate and restrict the reach of such information through their Information Technology Acts, through their Free Speech Acts, Your Excellencies, thereby meaning that there is no control over this stratum by XDAO. Furthermore, as far as the societal stratum is concerned, all societal relationships within the cyberspace are again controlled by domestic legislations, Your Excellencies. The state decides as to what organizations you can be a part of and what organizations must be banned and restricted and regulated, Your Excellencies. Therefore, considering that XDAO does not control any stratum of cyberspace, any claim to independence in essence or in effect cannot be fulfilled, Your Excellencies. Apart from states meddling with the affairs of the entity, it is also true that individual developers can choose to meddle with the affairs of the decentralized autonomous organization, Your Excellencies. To demonstrate the same, the case study of the DAO must be noted. The DAO was the first decentralized autonomous organization that gained prominence, Your Excellencies. However, a large part of their fund, which was in the cryptocurrency known as Ethereum, was stolen. What this led to is the fact that the core developers of Ethereum then decided to execute something known as the hard fork. This essentially led to the erasing of the transactions that led to this theft, Your Excellencies. Which is to say, without the consent of the decentralized autonomous organization, the developers of the blockchain, that is EtherX, can choose to remove certain transactions, thereby meaning that not just states, but even private individuals have authority over XDAO as an organization, Your Excellencies, therefore defeating any claims to independence. If I may proceed, Your Excellencies. Much obliged. Your Excellencies, this then brings the agent to the other 4 conditions of statehood under Montevideo Convention as established and considered by the applicants in this case, Your Excellencies. The first one is the condition of defined territory. As Your Excellencies have also pointed out, it becomes important that there is discrete territory separated from other territories and that this territory is demarcated. This was also held, Your Excellencies, in courts in the North Sea Continental Shelf case by this very court. However, in the current case, Your Excellencies, no demarcation of cyberspace is possible without it being an extension of the physical territory, Your Excellencies. If we are to see case studies of states such as Democratic People's Republic of Korea or the state of Iran, they have essentially established sovereign national cyberspaces. But this, Your Excellencies, are an extension of the geographical territory that they already control. Similar analogies might be, Your Excellencies, that the law of seas, the law of airspace emanates from the geographical territory under the control of the state, which is to say the yardstick for what is controlled by a state at the end of the day falls upon the geographical territory that it controls. Considering that XDAO does not have any geographical territory, any claims to demarcation or any claims to discrete territory in cyberspace is futile, Your Excellencies. Furthermore, as already stated, it becomes important that there be governmental control over such territory, because this is what separates property and territory under international law. Just because a certain person owns property does not make it defined territory under international law, Your Excellencies. However, control again is not established on the part of XDAO because, as already stated, all layers of cyberspace are within the domestic jurisdiction and the prerogative of different states, meaning that XDAO does not have any control over the territory if cyberspace can be considered territory in the first place, Your Excellencies.
Just one thing on that.
Indeed, Your Excellencies.
It says that there were 5 million members and supporters of this particular XDAO.
Indeed,
And they had a primary objective.
Indeed, Your Excellencies.
Now, if they have a certain defined number of members and they are controlling their particular primary objective, wouldn't that then qualify something analogous to a state because they are controlling those people?
Indeed not, Your Excellencies. While permanent population is a criteria under Montevideo Convention, it must be noted that the state must have effective control over this population. Just to demonstrate the same, there are various organizations like Red Cross or Amnesty International which have a lot of members, but these are not considered state because these organizations cannot effectively control the population, Your Excellencies. And this is true in the current case, Your Excellencies, because as already established, while there might be 5 million people who have some semblance of allegiance to the organization known as XDAO, all their actions are already within the domestic jurisdictions of the state, which is to say if a state tomorrow decides that XDAO, no citizens of its country can join XDAO, no citizens of its country can go ahead and join XDAO, Your Excellencies. Furthermore, evidence of participation in decentralized autonomous organization are granted through what are known as tokens, Your Excellencies. These tokens in domestic jurisdictions such as the United States of America have already been considered as security under their respective security laws, which means that it makes it open to domestic regulation. Therefore, if the evidence of citizenship or if the grant of nationality by the entity itself is under the regulation of another country or it is subject to restriction of another country, there can be no claim to permanent population, Your Excellencies. I hope that answers your question. Much obliged. Your Excellencies, therefore, having proved that the conditions of defined territory, of population and of independence are not met, the agent proceeds to make submissions on the condition of effective government. As suggested in Ackenhardt's modern introduction to law, which refers to the Allen Islands case, which had an international committee of jurists appointed by the League of Nations, suggested, Your Excellencies, that there are twin conditions to be fulfilled for an effective government. These conditions, Your Excellencies, are one, that there is an ability to act autonomously, and two, that the state can establish law and order within its territory. Both of these conditions are not met, Your Excellencies, because one, as already established, there is no autonomy to act. There is no autonomous nature of the ex-DAO to act. Furthermore, as far as law and order concerns are regarded, Your Excellencies, the law and order situation within ex-DAO is again not within its control, because let's say there is a crime within the cyberspace. The prosecution of this crime cannot happen by ex-DAO because it does not have any physical territory. Therefore, the prosecution of this crime or the maintenance of law and order is again the prerogative of the domestic legislation, Your Excellencies. Therefore, considering that law and order functions and the ability to act autonomously are not within the control of the purported organization in the current case, the agent humbly submits before this court that the condition on effective government is also not fulfilled. If I may proceed to the condition of the capacity to build relations with other states, Your Excellency. Much obliged. Your Excellencies, the capacity to develop relations with other states today is not an exclusive right of the states. Multiple multinational organizations, multiple transnational companies today develop relations with other states. Then what makes the ability of a state to build relations unique, Your Excellencies, is the conflation of two conditions, independence and effective government. Because only an independent and effective government can act as the agent of a certain state and develop the relations necessary for its functioning with other states, Your Excellencies. However, as established by the agent already, neither does independence exist, nor does any semblance of a stable political organization or an effective government exist, Your Excellencies, thereby meaning that this organization as a state does not have any capacity to build relations with other states, Your Excellencies. Therefore, the agent humbly submits before this court that the 5 conditions necessary under international law for the grant of statehood are not fulfilled, and as such, ex-DAO, an organization that is without its own population, without a territory to call its own, without any semblance of political organization, with no law and order, should not be considered a state by this honorable court, Your Excellencies. This brings the agent to the final submission in this issue that non-governmental organizations do not even have international personality, Your Excellencies, if I may make those submissions. Much obliged. Your Excellencies, while there have been several attempts at providing international legal personality to NGOs, if Your Excellencies may kindly refer to marker number 18, that is page number 211 of the compendium provided. If I may proceed. Yes, Your Excellencies. Your Excellencies, it is very clear, as suggested by the scholar, that in general, NGOs do not enjoy legal personality under international law. Further, Your Excellencies, the closest international convention that came to defining international personality of NGOs is the European Convention on Recognition of the Legal Personality of International Non-Governmental Organization. However, this very convention under Article 2, Your Excellencies, suggests that NGOs are obligated to accept the national legislation of the state in which they have been established or they are based. If Your Excellencies may kindly refer to para 2 of the Moot compromise. Para 1, apologies, Your Excellencies. It suggests that ex-DAO is a non-governmental organization based in Zimbabwe. Therefore, any claim to statehood does not exist, Your Excellencies, because they do not even have legal personality under international law. And if not for states, no one else can have international personality under international law, Your Excellencies, because states are the makers and the enforcers of international law within the global sphere, and not having international legal personality is conclusive against any claims for statehood, Your Excellencies. If Your Excellencies are satisfied with the submissions made, the agent will proceed to make submissions on issue 4. Much obliged, Your Excellencies. Your Excellencies, issue 4 is the question of whether the state of Avantara is obligated to financially reimburse the state of Zimbabwe for the losses incurred. Your Excellencies, while the learned agents for the respondents have given the court a computation of the damages, Your Excellencies, the respondent humbly contends that the question is not how much the compensation is, but whether compensation or financial reimbursement must be provided in the first place, Your Excellencies. If Your Excellencies may kindly refer to marker number 16, the compendium provided, it suggests as to how the commentary to Article 31 of RCWA suggests that criterion such as directness, proximity and foreseeability may be used to attribute damages to the entity that has acted, Your Excellencies. Which is to say, the question is whether the actions of Eagle Eye were direct and proximate to the financial losses incurred, and whether it was foreseeable that the actions of Eagle Eye would bring the damages that it has caused, Your Excellencies. Your Excellencies, as far as the question on directness and proximity are concerned, the action of Eagle Eye, Your Excellency, was foreseeable only to bring down the Crimson Road. In this measure, it so happened that this resulted in the bringing down of the EtherX network. This then led to the corruption of Bitnero data. This corruption led to the news that this devaluation will commence, and further led to the commencement of the devaluation of Bitnero. This then, if I may get an extension of much obliged, Your Excellencies. This then led to the devaluation of Bitnero, leading to a loss to the state of Zimbabwe, Your Excellencies. Therefore, the agent believes it is established that there is a long causal network for the actions of Eagle Eye to be considered direct or proximate to the damages incurred, Your Excellencies. Further, it must also be noted that in the current case, Your Excellencies, the foreseeable result of the actions of Eagle Eye were not the loss to the state of Zimbabwe, but rather the bringing down of the Crimson Road network, Your Excellencies. It was not foreseeable that the actions of Eagle Eye would lead to a direct or proximate result of harming the interests of Zimbabwe, Your Excellencies. Considering that the actions were neither foreseeable nor direct or proximate, the agent humbly submits that the state of Avantara is not obligated to financially reimburse the state of Zimbabwe in the current case.
At this point, very on that,
Indeed.
the applicants are right in contending that this was an illegal act on your part.
Indeed, Your Excellency.
Then, for reparation, it is to wipe out all the consequences of the illegal
Indeed, Your
act.
Excellency.
So therefore, it means that they have to be restored.
Indeed, Your
Whatever
Excellency.
loss they have caused, that has to be restored.
Indeed, Your Excellency.
So, what do you have to say with regard to that?
Apologies. Your Excellencies, as effectively demonstrated by my co-agent, it is true that there has been no internationally wrongful act. In arguendo, even if we are to believe that there is an internationally wrongful act, Your Excellencies, the act must have had a direct, proximate and foreseeable result leading to the damages incurred, Your Excellencies. Just because there is a wrongful act and on a far corner of the world there has been a loss incurred, it cannot so happen, Your Excellencies, that the state should be held responsible for compensation. And this is provided under the commentary to Article 31 of RCWA. Therefore, Your Excellencies, considering that as established by the agent, the losses incurred were neither direct or proximate or foreseeable by the actions of Eagle Eye, the agent humbly submits before this Honorable Court that the state of Avantara is not liable to compensate the state of Zimbabwe, Your Excellencies. It was an honor arguing before this court.
Would you like to rejoin for 2 minutes? Please.
Your Excellencies, there seem to have been multiple logically infeasible and unacceptable interpretations of international law that seem to have been taken by the other side. We seek to provide glimpses of a few of them on each issue. On the first question of issue 1, there seems to have been a conflation of the standards of sovereignty and use of force. My friends on the other side seem to have argued that insofar as Bitnero is located on the cyberspace and the state did not exercise any control over it, they could not have claimed sovereignty over it. However, the thrust and focus of the principle of sovereignty is on the ability to make a decision and exercise functions in certain crucial areas for a state function. An example would be certain African states that adopt the dollar as their currency. Here the protection is not for the dollar that they have adopted, but for their ability and choice of adopting that currency as their financial system. On the second prong of the use of force, my friends on the other side seem to have relied on the BCLT, particularly Article 31 Clause 1, which argues for an ordinary interpretation and a contextual interpretation of the terms of the treaty. As we have highlighted in our arguments, there has been an expansion of the realm of threats that are posed to the political independence and territorial integrity that Article 2 Clause 4 aims to guard against. There has been no clarity on why such an expansive interpretation must not be taken to guard the essence of what constitutes the protection provided by Article 2 Clause 4. On the second issue of attributability, my learned friends have sought to rely solely on the subsequent conduct of Eagle Eye, conveniently ignoring the fact that they have created the system, as well as any actions that it takes through its seemingly autonomous actions, benefit what constitutes their national security. This constitutes a clear attempt to evade their responsibility. Moreover, Article 4 does not require an internal law requirement. If I may just conclude. Moreover, as my co-agent has demonstrated, there were multiple other alternatives that they could have taken to bring down and achieve the same objects that they sought to achieve here. Finally, on issue 3, we submit that they have not provided a reasonable explanation to why an expansive interpretation of a treaty that came into force in the 1930s must not be taken. And to finally rebut their independence argument, we have the very case of India. India continued to be a state even during the period of a colonial realm, even when it did not exercise independence. The fact of independence is not a component of the Montevideo Convention. The only requirements for a state to be recognized is the fulfillment of the criteria provided by the Montevideo Convention. With that, we rest our case.
If I may begin. Your Excellencies, as far as the question on sovereignty is concerned, the agents seem to have misinterpreted assets with currency, because assets such as oil, even their case that African states adopt dollar, does not mean the USA will tomorrow be held liable if they devalue their own currency. Therefore, sovereignty is an important part that you should be able to control this asset for you to be held liable, Your Excellencies. As far as the expansive interpretation is concerned regarding independence and India, Your Excellencies, except for there being a viceroy in the country, all governmental functions are already being carried out by the representatives of India, which is not the case with XDAW, Your Excellencies. It was an honor.